Yo, memo mo akwa bastron koso e aba POG Media so message sa afei and I say waba ayi dwumadie no so a obe subscribe like dwumadie no share na ma afoforo and so and sa and can be kindly click on the notification bell no so send be the any news bia to platform no so a won so well hunu de echo any de by in Ryan some na yem find some dodo no embrewa aye former chief justice Madam Aye Torkono and I say Gertrude Aye Torkono. Me I nim the one some ebe ye deja ewo Ghana ha abra ye ni ye de and I say the processes are ye di no na do na chiro madwene ewo ho ene kwan kra de fast yi no na do na so chiro madwene ye de ewo ho na ye ni wie ye no Mami and I say former chief justice also on the ompene na yina yi no still na to say oda so ewo trimka ekakra ayede ewo ho echemu a enye ne kwan paso na ye fa so ede yi no efiri ho no munti ono obere obekọ na wakwa ye de kosiki for a justice na enim say dikan ko ECOWAS court wakọ be court is like court bebre a say air try so basically a justice but mokobia na ajiegu but still na maame no mo se na ba munye de embu obekọ so na wa fight for a de and also wa fight for the rights and de de edman ebi mo esusu say enka ehun ye de ehun hia unnecessary because oye de ya ye de ye maybe so chere say eja se okwa ebia na atentene ne aye de akasa na we na eye omrani nimba ko apa ibu no ewo Ghana ha aye ura Martin Pebu akasa ewo saa ade no wo chere se hwe we nsema ne nyoma ode ko nyina no ehun nye de ehun hia na ye say ochiremu a allegedly no ohwe baby a asem no ebekwa akosi a eye de amaame no obidi entwonti ne nkehun hia echeche din kasa dodo na ye de etudwa na chese enye easy ochiremu ede nyoma bebre ye de etudwa yenko kuti eye ura Martin people nsem a ode tudwa abra chief justice ura eye another court to seek a justice.
This application now is questioning that power by the president to remove her from office as a justice of the Superior Court. Now, you've seen the reliefs and the grounds right now. I want to first of all find out from you if this really, from where you sit, how this strikes you and whether it reflects exactly what the position of the law is.
Yeah, so Mr. Kansi, my first comment is that when I saw, I wasn't seeing, I heard the information, okay, on a radio station. I was flabbergasted, extremely surprised that we could have this new kind of litigation. I'm extremely surprised because, you see, that's if we go straight into it. When you look at Article 146, right, there is only one provision that deals with grounds on which the justice of the Superior Court may be removed from office, and that's Article 146 Clause 1. So my point is that there is no other place in Article 146 that you specifically find grounds for the removal of a chief justice. There is none. There is none. When you go to 146, you won't find that the what do you call it?
Yes.
There is any other provision that. So the point is this: if Chief Justice Torkono is saying that she was not removed as a Supreme Court judge, then I would have expected that when she went in there, she should have challenged the grounds to say that the Constitution does not even make any grounds at all for the removal of a Chief Justice. If she had made that, that would have been more plausible, because when you look at it, of course, there's a Supreme Court decision that says that administrative functions, blah, blah, blah. But she's going by the wording. The reason I'm saying that she should have raised this argument is that in 146, you don't find a specific provision that says that the grounds for removal of a chief justice are incompetence, stated misbehavior and the infirmity of mind and body. There's nothing like that. So that is what she should have raised first, because this new lawsuit sounds in a literal reading of the Constitution. But when you read the Supreme Court decisions, Ejechum, and then this recent one, her own case, you see Justice Tanko making the point that her removal as Chief Justice also affects her removal as a Supreme Court judge.
I see. But then she references in the reliefs, and counsel, if you permit me, and this specific one that she is asking for, that this declaration that the jurisdiction to hear a petition for the removal of a Chief Justice of the Superior Court from office lies with a body. She said there has to be a body essentially properly constituted under Article 1464 of the 1992 Constitution to actually take or hear or has that jurisdiction to hear the petition for the removal of the Justice of the Superior Court and not the Chief Justice. So if you look at 1464 that she references, it says where the Chief Justice decides that there is a prima facie case in the instance of the removal of a Superior Court judge, he or she, in this case she, shall set up a committee consisting of 3 justices of the Superior Courts or chairman of the regional tribunals or both, appointed by the Judicial Council, and 2 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers, and who shall be appointed by the Chief Justice on the advice of the Council of State. She wants this to apply. Counsel.
No. So the reason it won't apply once again is this. One, as I've already said, in her own case, when it came to the ruling on the injunction matter, okay, so that's the when her ladyship, Justice Gertrude Torkono, plaintiff applicant against Attorney General and the chairman of the committee. In that case, when you listen to the ruling of the Supreme Court, and that's Justice Tanko, let me read it. He says, I need hardly say that I arrived at the conclusion that this application must fail without relish, mindful of the fact that the applicant, the Honorable Lady Chief Justice of the Republic, is going through a process that may define her career on the bench as Chief Justice and as a judge, one way or the other. You see it? And then when you go to a J2, the same thing. They cannot be decoupled. No. And even so, with what the Chief Justice is actually seeking, then now maybe she wants a proper interpretation, so-called. You see, in law, to be fair to her, sometimes they can say that, oh, the matter that was before the court in a J2, Derry, and then this Justice Torkono herself versus AG and Scott Wama did not directly answer the question. There was no issue before the court that when you are removing CJ, are you also removing the CJ as a judge of the Supreme Court? Yes, there is that kind of argument that can be made, all right? Sure. But if you do that, that's why I said, then the first ground that should have been attacked is that because the Supreme Court has already given this interpretation in a number of those cases that it affects her as a person both as CJ and as a judge of the Supreme Court. So if the Supreme Court decisions are not persuasive enough, then the argument, she can make the argument, the first argument she should have made is that in the Constitution, the grounds for the removal of a Chief Justice have not been provided. Do you get the point I'm making?
Yes, indeed.
There are no grounds for removal of a Chief Justice in the Constitution. What is there is the grounds, that's the basis on which you can remove, are for Superior Court justices. Because that's the only way that this new argument she's making will make sense. Then also, there's a point that then this High Court decision case actually requires an interpretation of the Constitution. And so if that is the case should go to the Supreme Court, not the High Court. Yes, because before the High Court can make a determination that it does not affect her as a justice of the Supreme Court, that will require detailed interpretation of the Constitution. And if that is so, then the High Court is not the proper forum. The case has to go to the Supreme Court. The High Court judge cannot do what Justice Torkono is asking for. No, it can't. It cannot be done in the High Court because that's a complete interpretation of the Supreme Court. And the High Court is not clothed with jurisdiction to do what is being sought there.
I see. So you say her argument or her case would have had some more grounding if this particular relief was with respect to her removal as Chief Justice, because that is not clearly stated in black and white in Article 146.
Yes, it's not in there. It just says grounds for removal of Superior Court justices, and the Chief Justice is a justice of the Superior Court because she's a judge of the Supreme Court. Okay, yes, so that's why it is court. But to say which part of the Constitution says if you want to remove the Chief Justice, these are the grounds clearly stated, no. Rather, you'll find in the J-Chum where the Supreme Court was explaining Article 146 and then gave some flesh, not total, but some flesh to the meaning of stated misbehavior, blah, blah, and said the Chief Justice can be removed, this. But that's in the J-Chum. And I'm saying that it's the same J-Chum, and in this case, her own case against Attorney General and Justice Scott Puama, where they said, if you are removing the Chief Justice, you are removing the Chief Justice as a Supreme Court judge. So what I'm saying is that if she has accepted that a Chief Justice can be removed, even though the grounds were not stated in the Constitution, but rather in a J-Chum, etc., then she has also accepted the same judgments that have said that when you are removing the Chief Justice, you are also removing the Chief Justice as a Supreme Court judge, because you can't approve it. In law, we say you take, okay, and then reject. No, there's inconsistency because all of these statements are in the same cases. So why do you go into those Supreme Court decisions, then you pick and choose and leave others? That's going to be difficult.
I see.
Yeah, so it's either you reject all or you accept all. But to pick and choose, this cherry picking, no.
I see. So the potency of the warrant of her removal, you say, can actually apply in both cases as Chief Justice and also as a Superior Court judge?
Absolutely. Because the Supreme Court has said that when you are removing the person as a Chief Justice, you are also removing the person as a Supreme Court judge.
Because in the warrant, the third relief that she's seeking, that's one of the questions she's asking, in fact, a declaration of, that the warrant of a removal executed by the president purporting to remove her from both offices is really unlawful. She says it's null, void, and of no effect. Counsel.
Yes, so we'll still come back to the same point. The Supreme Court says that it affects both, not once, at least twice. Maybe after tonight, I'll check in Derry, the Justice Paul Derry case. I don't think that one. But in the J-Chum and in Justice Torkono's own case, the Supreme Court says it affects both positions. So that's why I made the other point that then in that case, if she wants to throw out these statements, in other words, to say what in law we say obiter, because she said that was not the main question before the court, all right? It was collateral, or it was, yes, there was just some comments in passing. Then, in that case, if you said that was obiter, so how did you accept that a Chief Justice can be removed even though the Constitution does not prove the grounds, or the Constitution does not state the grounds? I find it difficult to reconcile this. Yeah.
We'll see how the coming days will look like on this matter. Counsel, I thank you. I appreciate you as always. Thank you for joining us. Nothing Pebo is private legal practitioner there. And there are two more reliefs captured in this latest application by the former Chief Justice. She's actually seeking an order of certiorari to bring into the court for the purposes of been quashed. The emphasis on the warrant of a removal referred in the C to quash the same warrant as being in violation of the mandatory provisions regarding the removal of a chief justice, of a justice of a superior court of judicature from office. That is one that Martin Bebo has consistently referenced cases that she herself as well presided over, and how the outcome of those cases, in his view, also goes contrary to the position that has been taken now. We'll see how this case flows. But as I indicated, this is a stone that is really gathering dust as we go on. But this is one we'll keep an eye on here on Ghana Tonight. But coming up next, let's still stay on the matters of law, because Ghana's deportation agreement with the United States has now brought about a fresh wave of lawsuits, this time from the deportees themselves. We'll tell you about it. Stay with us here on Ghana Tonight. And this is some information that we're getting fresh on the plate. And we've been watching how this has been developing over the period. 11 West African nationals have taken legal action against the government of Ghana. What's their crime, or our crime? Challenging their transfer from the United States under the controversial arrangement. Now, the applicants, who are Nigerians, Togolese, Gambians, and Malian nationals, say they were secretly removed from the United States detention centers earlier this month, despite having previously secured protection against deportation.
Yo, ofa mienu no na yede bro. But unsubscribe ya, subscribe, like Jumedi and share nema afufro and so and can be kindly click on the notification bell no so send the any news be out platform no so also wahunu de airco ene de air de air but Jumedi no ye beto aso na yede ofa mienu no ayede abremu yanko ne konkoti ofa mienu no
from American immigration courts. Now, they claim they only discovered later that Ghana was their unexpected destination. They didn't know about this. That's why they say it was a secret deportation. They didn't know that they were being brought to Ghana. But then again, what does the law say? Because since their arrival on September 6th, they say they have been kept in military facilities, denied proper access to family members, and held for more than 48 hours without any court order. The suits filed before the Ghanaian courts include a habeas corpus action questioning the lawfulness of their detention, a human rights case alleging violations of their liberty and administrative justice, and an injunction seeking to stop any attempt to send them back to their countries of origin. Now, let's get a bit more into this, because this is one that our legal affairs correspondent, Joseph Akablea, has been following quite closely as how this transpired right from the United States to what's happening here in Ghana. He's joining us right now. Joseph, it's good to have you. Thank you so much for joining us here on Ghana Tonight. What more do we know about this particular case and the challenge that these deportees are bringing up against the government of Ghana?
Well, the first update we can bring to our viewers is the fact that two of the cases that you made reference to are due to be heard in court tomorrow. The first being the habeas corpus application, which is simply challenging the basis for their imprisonment, asking that whoever is holding them shows up in court and explains why they are being detained, for the court to determine whether that detention should be allowed to remain or the court should issue other orders for their release. Then the second application is the one for the injunction that you also made reference to, which would also is supposed to be heard tomorrow, asking that the Republic of Ghana is restrained from having them removed from Ghana. We have seen and verified videos from persons who are close to these individuals, video showing one person speaking on their behalf, in which they say that as at the 15th of September, that is just 2 days ago, they were still in the jurisdiction. You recall last week, the president had said that the first batch had been sent out of the country. What is not clear is whether this is another batch beyond the batch the president had referred to, because they say that media reports suggesting they arrived in Ghana and they had been sent out of Ghana are false and that they are still within their jurisdiction. The main point to make is that they have been granted some respite by the courts in the United States of America that prevented their removal from that country, and they were not therefore supposed to be moved from the United States in the first place, only to be told mid-flight that they were heading to Ghana. And they say that on arrival in Ghana, without any court order or anything, they are being kept beyond the mandatory requirements of 48 hours, or beyond that, you get a court order to extend that warrant. And so that is what they are saying, that as far as they are concerned, they believe their rights have been breached, for which reason they are seeking the intervention of our courts.
And they say they are being kept at military facilities.
Yes.
As we see from what you do know.
Yes, that's the claim they make. They say that they are being held in various military facilities, and that there are intermittent access that is granted to family members and sometimes to the lawyers. So it's not access that they are satisfied with. And they believe that all those matters amount to a breach of their rights. And as far as they are concerned, they believe that the courts ought to intervene and order their release.
And Joseph, hold on a bit for me. Let's hear from the president exactly a week ago when he first spoke about this entire arrangement and these deportees coming into Ghana. Take a look. And we'll hear from him. And then Samuel Okujoto Ablako as well did give a bit more detail a couple of days ago during that accountability series. This is the president a week ago. Take a look.
It shows the tightening situation in our foreign relations, but I do think that we still enjoy good relations with the United States of America. We were approached by the U.S. to accept third-party nationals who were being removed from the U.S. And we agreed with them that West African nationals, were acceptable, because all our fellow West Africans don't need a visa to come to our country. So if they decided to travel from US to Accra, they don't need a visa anyway. So if you're bringing our colleague West Africans back, that's okay. And so I think that agreement has been activated, and a first batch of 14 nationals came. Several of them were our Nigerian brothers. They opted to go back home. And so we facilitated, we put them on buses, to be able to go back home. One of them was a Gambian who it's not as easy. You have to get him an air ticket to be able to facilitate his travel. So what we've done is contacted their embassy to let them know of his presence so that they can facilitate his return to Gambia. And so that's the issue with regards to deportations and arrivals. West Africa has the protocol of free movement. And so any West African is free to come to Ghana and be able to stay for 90 days. And so if they decide to bring them, we don't have a problem accepting them.
So that's the president there. So Joseph, he reiterates the point you made earlier that these West African nationals are due for their countries of origin under this arrangement with the United States. And that's what these deportees are resisting. They don't want to go to their countries?
Yes, in fact, they say that they should not have been removed from USA in the first place, because they say that they had been granted a certain status. And in fact, there's an international report by the Reuters which makes reference to a matter that has been put before a federal court, which raises questions about whether those individuals should be removed from the country. And so in this particular process that they filed in court, they attached some of those documents to show that they were pending matters, and there's also a certain status that had been granted them, for which reason they should not have been moved. Again, we are learning from our government sources that about 40 other nationals are expected in the country in the coming week as well, 40 nationals. And questions are already being raised about the nature of the agreement that has been reached, particularly in line with the Supreme Court decision in the Gitmo 2, the case of Margaret Banfo and Henry Nana Boakye versus the Attorney General, in which the court said that whatever form that agreement takes, Article 75 does not make any such distinction, and so such agreements ought to be taken to Parliament for ratification. But the government sources and the Minister for Foreign Affairs has stated quite publicly that as far as they are concerned, the agreement hasn't gotten to the stage that ought to go to Parliament for such an approval.
And so, from what you do know, when is this case going to be heard?
It's to be heard tomorrow morning at the High Court here in Accra.
Tomorrow morning. And we'll see how things play out. And I know that this is one that you're keeping clear focus on, and we'll be updating our viewers on it. Our senior legal affairs correspondent there, Joseph Akabale, thank you. Thank you so much for joining us here on Ghana Tonight. And okay, the Foreign Affairs Minister, Samuel Okudzeto Ablakwa, also gave some detail on the status of these deportees and what is going to happen, because they have to go to their countries. They say they don't want to go. But this is Samuel Okudzeto Ablakwa 2 days ago. Take a look.
Ghana's action was guided solely by our moral responsibility, our legal obligations under the 1992 Constitution and ECOWAS protocols, our distinguished Pan-African track record, and historic and legendary leadership in championing the rights of all Africans. Let me emphasize that under this understanding with the United States, Ghana must first independently vet the background of those the U.S. intends to deport, to first satisfy ourselves that they do not pose any threat to the security of our country and that they cannot harm our citizens. We have put in place strict safeguards to ensure that convicted, hardened criminals cannot be brought into our country under this understanding. The Mahama administration will never compromise the safety and well-being of Ghanaians. This understanding with the U.S. has been thoroughly discussed by Cabinet and has also received the Attorney General's advice. By established convention, MOUs are not sent to Parliament for ratification. I have inherited hundreds of MOUs from the previous administration, which were not sent to Parliament for ratification. May I assure the nation that if this initial understanding is elevated into a full-blown agreement, we shall not hesitate to comply with Article 75 of the 1992 Constitution by proceeding to Parliament for ratification.
Aha, any of the Jumedian ABC at the Amame unsubscribe, ya subscribe, like Jumedian share, Nema for Florence, so and can be kindly click on the notification bell so send a be the any news beyond at a platform so I want so well who the air call any day, but Jumediano made the BCA, Namely do do an idea, Ababe so much, Macramo.